We're on the record.
Thank you. Good afternoon. My name is Judge D'Angelo. I am the single justice for this afternoon's sitting. We are here on docket number 23-J468. Good afternoon, Ms. Rivera. Good afternoon, Attorney Vukmarovitz.
Good afternoon, Your Honor.
All right, so with that, both sides have 15 minutes. I have read all the papers. There is no rebuttal, so please use your time wisely. You certainly do not have to use 15 minutes. But again, Ms. Rivera, go right ahead. I'll hear from you first.
Your Honor, I would like an appeal on behalf of the judge's decision because the rent that Mr. Gaval claims I owe is inaccurate, and he has put money in his pocket. I have emails where this man is admitting to taking money, not putting it towards my rent in order to get more money from RCAP. I have emails right here in front of me where he's also saying that he gets paid $80 an hour to stand in court and be believed anything he says, and to pick and choose wisely what I say to the judge because I will look stupid. He is pocketing money and he's admitting to it. And I have the emails right here, Your Honor.
Okay, and Ms. Rivera, did you present that paperwork to the judge in the housing court?
The other paperwork I did, these ones I didn't. These ones I didn't have access to. Okay.
All right, you can continue. Go ahead.
Okay, the decision where he decides not to waive the $7,000 fee, he says that it's frivolous. With all respect, it is not frivolous because it is my home, and I am working and I'm getting help from City Hall as we speak in order to uncover everything that Mr. Gaval is doing. There's only so much we could do at a certain pace. But just the fact that, he finds it frivolous is a little offensive because it is my home that I am desperately fighting for.
Well, ma'am, and I'm not here to protect the lower court judge. That's not my job at all. When he says it's frivolous, it's not that he thinks that it's frivolous, that it's your home. It's frivolous in a legal sense that he's making a finding that you don't have a legal defense. And that what he specifically finds is you do not have a non-frivolous defense. So I just want you to know, he's not saying that it's frivolous, that you might be kicked out of your home. What he's saying is that the legal defense that you put on, he did not find it had merit. So I'm not protecting him or her. I just want to make sure you understand what he wrote. So that might help your argument a little bit more. Okay.
Thank you. As well, it has been very difficult for me to speak up in court because I don't know legal terms, which I am currently looking for an attorney. I just haven't had much luck with an attorney in my budget, but I feel like it's in my best interest that I go forward with an attorney beside me. It's only fair, I think.
All right. Is there anything else you want to say before I hear from Attorney Vukmarovitz, because there is no rebuttal after he makes this argument?
I would also like to clarify that Section 8 is no longer paying rent because he refuses to fix anything wrong with the apartment. And last month they told me not to pay, but it's weighing on my nerves, so I can't do that. I'm gonna continue giving my portion like the judge told me to do as of September.
Okay. All right. Thank you very much, ma'am. And I know this is a difficult situation. You argued very well. Thank you.
Thank you, Your Honor.
Okay, Attorney Vukmarovitz, I'll hear from you.
Thank you, Your Honor. Good afternoon. May it please the court. I represent the landlord appellee, 15 Woodman Road, Worcester Realty Trust. As indicated in my filings, Your Honor, there's no contention with the first part of the two-pronged test that Ms. Rivera has to satisfy that she's indigent. There never has been. However, the second prong of the non-frivolous grounds of appeal, that is the problematic part of the test that she doesn't meet. As indicated by the docket attached as Exhibit A and also referenced in the opinion after the jury waived trial in paragraph 3, and that's submitted as Exhibit B. This case started by a notice to quit back in November of 2022. So this isn't like a blindsided couple of week-long process. Ms. Rivera has had full and ample opportunity to prepare for this trial, to know what has been happening. We had the trial. I submitted her motion to stay, which was accepted as her notice of appeal. I only found it on the docket of the housing court, but the emails I think that you had inquired about that she admits that she didn't provide to the trial court submitted in that motion I've never seen before, and it wasn't provided. The trial court referenced the exhibits, which she had no problem printing out, including emails and whatever she introduced into evidence. This notion of my client pocketing money, that was raised at the trial. That was specifically addressed in paragraph 7 of the decision, which talks about almost a $4,800 payment back in February of 2022. That was in contention. However, my client did testify, and a ledger was accepted into evidence, as referenced in the opinion, that confirmed that those funds were applied and duly accounted for, and notwithstanding the contention that they weren't, they fit within the ledger and the calculations, and that is what the rent arrears were calculated upon. So there doesn't appear to be any non-frivolous ground of appeal. That's the substantive argument. The procedural argument, I'm not sure if this was timely, is attached as Exhibit F as Ms. Rivera's notice of appeal to the single justice, and in it she acknowledges receiving the decision on August 10th, and the appeal. This notice was filed on August 21st. I realize that I think the 21st was on a Monday, so maybe because the weekend fell on the 20th. Yep. But the form does state this request is timely made, as it is made within 6 days of the date she received the order, which wasn't the case. This is well past 6 days. So I just put that out there, Your Honor. But substantively, I don't think that there's any merit to this. Ms. Rivera has certainly every right to appeal, and with or without a lawyer, but my client has the right to obtain its damages through the appeals process, and we contend that she should pay the appeal bond order and the ongoing monthly use and occupancy.
Okay. All right. Thank you all very much. I will issue my order as quickly as I